Hello there, estate planning mom here, Crista Hermance. Today we're going to be talking about estate planning questions and answers. This is going to give you an opportunity to submit any questions that you have on estate planning. So wills, trust, probate, trust administration. Um, so there is a lot for us to cover. So again, if you are just joining me live, my name is Crista Hermance. I'm an estate planning attorney licensed in California. And I'm going to be answering some of your estate planning questions. So anything specific to what is a will, a trust, advanced healthcare directive, power of attorney. If there's somebody that has passed away, specific things related to trust administration, probate court. We do have some questions that were submitted previously in preparation for this question and answer. But if you are joining me live and you have any questions on estate planning, please feel free to put those in the chat. We do have people joining. Hello, welcome. So the first question that I have is what a trust can do that a will can't. So for me to answer this question, I want to kind of just give you an idea of what the difference is between a will and a trust. So a trust is a legal agreement between the person who creates it, the grantor, and the trustee. The trustee is the person who agrees to hold legal title to all of the assets in your trust, and they will follow the instructions in your trust for the benefit of your beneficiaries. So while you are alive and you have a revocable living trust, you are all three of these roles. It's only once you pass away that's when your successor trustee or executor would step in to be able to manage the terms of your trust. Okay, so that is in a nutshell what a trust is. A will, on the other side, is a legal document that allows you to identify what assets you want distributed at your passing. If you have minor children, it also allows you to nominate guardians for those minor children. A will only comes into play when somebody passes away, and that's when it is filed with the court. So it has no procedure, or it provides no resource to be able to do anything if somebody is sick, right? It only comes into play when somebody has passed away. And so what a trust can do that a will can't is a trust is with you throughout your lifetime. And when you pass away, it follows your instructions. So if you were to get sick, it has specific instructions on how you are to be cared for using the assets of your trust to be able to take care of you. A will cannot do this because a will only comes into play when somebody passes away. And so this is where that trust has a lot of flexibility and provides a lot of protection. The other thing that I will say about something that a trust can do that a will can't is a trust can avoid an estate from having to go through probate court, whereas a will almost guarantees probate court because it's telling the court how to distribute the assets. And so having a trust keep things private, right? It keeps generally the cost down from having to go through those probate fees. And so that is another thing that a trust can do that a will can't. Okay, so hopefully that answered your question. If you are just joining me, I'm doing estate planning questions and answers. If you have a question and you are joining me live, please put that in the comments and I will try to get to it. If you are watching this in the replay, if you put your questions in there, I will try to get to it next week when I go live again. Okay, next question that has just come in. Does the remaining balance on my mortgage have to be in the trust? Okay, so I'm trying to figure out how to answer this. So so it's not necessarily a mortgage that's going to be in your trust, it's the house that's going to be in the trust. So let's say it's your primary residence, you have a revocable living trust, and you do a transfer with a deed, transferring title from you as the owner of the house to you as the trustee of your trust, right? So now the house is in your trust. The mortgage is associated with that house, so it's going to follow it into the trust, if that makes sense. If there is a balance owed on that mortgage and something were to happen to you, then it's a decision of, well, what's going to happen to the house? Is the house going to get sold? In which case, the proceeds from that sale are going to go to pay off the mortgage. If the house is going to get distributed as like a specific gift or something to somebody that you're giving it to as part of your trust, then at that point, they can take over the mortgage, work with the mortgage company to try and do the paperwork to take over whatever that balance owed is due. So I'm hoping that answers your question for you. Okay. Okay. If you have any estate planning questions that you need a plan, right? A will, a trust, um, power of attorney, advanced healthcare directive, please send us a message and we will get a link sent to you to be able to schedule a free consultation on getting your estate plan set up. Okay, so a few more questions that have come in. What is a trustee position? What are their responsibilities? Okay, so great question. So when we refer to a trustee, that is generally somebody that is like an executor of a trust. And if they are in that responsibility, let's assume that the person has passed away that created the trust. And now this trustee is coming in as a successor, right? To now administer the trust after someone has passed, right? So now that we have those kind of few facts, let me talk about what the trustee is actually supposed to be doing. So a trustee they have a fiduciary responsibility, right? And they could be somebody that is a beneficiary of the trust. We see this a lot where there's adult children that are the beneficiaries of a trust, and one of them are now the trustees. Well, while they are a beneficiary, they have this fiduciary responsibility to make sure all of the beneficiaries of the trust are being provided accurate information, that they're getting the information that they need, they get proper notice, they get a copy of the trust. The trustee's responsibility is to gather the assets, make sure that they are secure. As they're gathering assets, it's bringing those assets into an estate checking account. It's figuring out if there's investment accounts, bonds, stocks, anything, and figuring out what's going to be needed to get those assets to be able to either cash them out and transfer them to the beneficiaries, or just do a straight transfer to them. But it's a lot of that, keeping those assets protected, keeping the beneficiaries updated, potentially selling a home if there's a home involved, making sure notice goes to all of the beneficiaries regarding that sale. If there's assets in the house, how are those assets to be distributed? Any type of accounting that needs to be done, being able to have that available for the beneficiaries, completing taxes for the estate and the deceased. And then at the end, it's going to be distributing, right? There might be some distributions that are done prior to the end, but at the end, making sure that any of those assets that are in the estate are distributed according to what those terms of the trust are. Okay. Hopefully that helped you, Gina, on what the trustee position is and what the responsibilities are. If you have any other questions, please put that in the chat, but thank you for that question. And if you're just joining me, my name is Crista Hermance. I'm an estate planning attorney, and I'm going through estate planning questions and answers. If you have any questions, please put those in the chat. I do see a few that have come in. If you need to put an estate plan together and you are located in California, we service clients all throughout the state. Please send us a message and we can get you the link to get that free consultation scheduled to look at getting an estate plan created for you. If you are not in California, please send us a message, as we work with attorneys all throughout the country. And it is best to work with an attorney in your state to be able to make sure that they understand what is required as of your state, as each state is different. Okay. Okay. Next question that has come in. Does a revocable living trust avoid capital gains? So a revocable living trust isn't going to avoid capital gains, but what it can be done is, from a tax perspective, let's say that you have, there's planning that can be done, right? But it needs to be done correctly in order for those capital gains taxes to be avoided. So let's say that there is a home that parents owned that they purchased in 1970. They purchased it, let's say, for $50,000 in 1970. And they put this home that they owned as a married couple in their revocable living trust. And now they have both passed away. And let's say as of 2020, both of them have passed. The home has been in the trust. And in their trust, they want, well, let's say 2025, because we've now gone up 5 years. So let's say they've passed, it's now 2025. And in their trust, they want that home to go to their only son. Okay. What then will happen is that the house would get a step up in basis from the date of the 1970 purchase of $50,000 to now the home being worth $1 million in 2025. So those capital gain taxes from $50,000 to now $1 million would be avoided by having it in the trust and being distributed to their only son at their passing. Where I see people doing this incorrectly is, let's say they just add their son to title, right? At that point, there is no step up in basis. It is not distributed at their passing through the trust. And so there are ways that people will do this incorrectly and lose that advantage of not having to pay capital gains taxes. And so this is one way to be able to do that. Okay, I hope that answers your question. Okay, if you are just joining me, again, please put in your estate planning questions and I will try and get those answered to you live. If you're watching this in the replay, go ahead and put your question in there and I will try to get to it next week when I go live again. And again, if you need any estate planning in California, that's where we service clients as we are licensed, please reach us in chat. You can put protect in the either in the chat or put it in a message to us and we will get a link sent to you to be able to get that appointment scheduled. Okay, so next question that has come in, Blue Ink Notary in California, hello again, thanks for joining me. So what is the best way to facilitate a creation of a trust with a couple who is divorced and can't agree on a caretaker for the children? So divorce, when it comes to estate planning, is definitely tricky, but it's so important. And the reason is that when a couple is now divorced, they each have their own estate plan. And so in this case, if they can't agree on a caretaker for the child, they don't necessarily have to agree, right? It's what their wishes are because they have their own estate plan. They have their own guardianship nomination that they're going to be able to say, here's who I want. They don't necessarily have to agree because if it ever came down to it that something happened to both of them, both of those guardian nominations would be given to the court for the court to be able to say and look at, here's who the parents wanted, right? And then the court to be able to decide on who they think is going to be the best fit for a guardian. The other reason that estate planning with divorced parents is so important is because in most of the cases I've seen, and I have seen some amicable divorces where parents are still getting along and they're looking out for the best interest of the children. Most of the time when I see this is that they don't get along well with their ex-spouse. They don't trust them with the money. They don't want them to have access to all of the money if something happens to them. And so this is where having a trust is so important because now when you are divorced, you can say in your trust, well, this is my separate trust, right? It's my personal trust. It has nothing to do with my ex-spouse. And if something were to happen to me, here are the trustees that I would want to be in charge of the money if something happened to me. And so you could list your parents, your siblings, a friend that you trust, somebody that's over the age of 18, as long as they're a U.S. citizen, they can be the executor or successor trustee of your trust. But then what that does is it says, well, if something happens to me, let's say I have this life insurance policy worth $500,000, I don't want to list my minor children as beneficiaries on that life insurance policy because they can't actually inherit it. It would then have to go through court and get guardianship, and it's most likely going to be the ex-spouse that is going to be the one that's going to be guardian of their assets, and now they would be in charge of that money. So if you had a trust, you could say, well, Instead of listing my minor kids, I'm going to list my trust as the beneficiary. So that life insurance policy would go into trust for the benefit of my minor children. And now the trustee that I have chosen as my beneficiary, or I'm sorry, as my trustee, can manage the money for my kids, right? So you have a lot more flexibility and control to be able to have what you want done if something were to happen to you. So it stays out of control of your ex spouse for the benefit of your kids, managed by somebody that you trust. Okay. Okay. I hope that answers your question. Thank you for joining. Hello, hello. Okay. Next question. And again, if you need help in creating your estate plan, if you have family members, I know a lot of times when we're doing a lot of the stuff that we do online, it's people that are needing information and needing estate planning done for their parents or their grandparents. And so this is the perfect opportunity for you to act. So put a comment in the chat, send us a message, and we will get that linked for the free consultation scheduled so that your family members can get their plans in place. Oh, I'm glad that that was helpful. Absolutely. Great to see you again. Okay, next question. And if you're just joining me and you have questions, please put those in the chat, as I do see quite a few questions in there. So I'm going to try and get to those. What happens when you file for divorce but get declined? So this is going to be a family law question that I cannot answer for you. I'm sorry. If you do need a family law attorney, please send me a message and we can try and get you a referral to a family law attorney. Family law is more in the divorce region in that type of law. We do estate planning, and so it's going to be wills, trust, probate, trust administration, planning for incapacity if somebody passes away. Okay. Okay. Oh, thank you for that. Okay. Oh, thanks, Gina. Appreciate that. Awesome comments coming in. I love the live today. You guys are amazing. Okay, next question. Should my dad put on his will that he wants to be the owner of his company? That he wants me to be the owner of his company. I don't want my stepmom getting it because she's going to leave me with nothing. My stepmother and I have problems. Okay, so a lot of blended family situations have problems. And the best way to prevent those problems is to have the paperwork done before somebody either gets sick or passes away. So, whatever your dad wants, he absolutely needs to put it in writing in either a will or a trust. Um, in California, generally, we would have both a trust and a will, and they would work together. And so it would having a comprehensive plan that makes sure whatever dad's wishes are pertaining to the business is going to be put in either of those documents, right? Whether you have a trust, putting the specific instructions in there so it says exactly what dad wants, and then while also putting it in a will if maybe there is no trust. Without having it in there, it's hard to say, especially not knowing the facts or not knowing what somebody's going to do, what could happen without it, right? And this is where the cost of when somebody passes can be so substantial when it comes to probate court, because I mean those fees can range in something where you're fighting over a business. 10, 20, $30,000 in legal fees that could be prevented by just having it updated in that document. Okay, so hopefully that helps you, but definitely making sure dad has some kind of language in his will of what his wishes are. And you can approach it with dad also and just say, dad, if this is really what you want, I just want to make sure that it's very clear between me and stepmom that whatever your wishes are in writing so that there is no confusion. And that's going to make our relationship better for something that we've already had problems with. Otherwise, it could get messy. Okay. Okay. So if you're just joining me, my name is Crista Hermance. I'm an estate planning attorney. Our firm is Hermance Law, where we are licensed to practice law in the state of California. So if you're not in California, this is still really great information. It gives you an idea on things that you should be working with an estate planning attorney in your state. If you do need a referral for an estate planning attorney in your state, please send me a message, as we have attorneys all over the country that we work with. So if you have any estate planning questions, please put those in the chat. I do see a few more questions here that I'm going to get to. And if you are watching this in the replay, please put your question in there, and then I will get to that next week when we do our live next week. And if you are looking for a free consultation, please put protect in the chat or send me a message, and we will get that link scheduled to get your free consultation for an estate plan scheduled for you. Okay, next question that I saw come in. What tax implications do you consider when creating trusts for clients? Do you let the CPA handle those tax considerations? Yes, so I am not a CPA, right? I'm not in the tax world. There are certain things that we look at when it comes to capital gains taxes. What are the best ways for clients to get that step up in basis? We're going to look at property taxes, looking at things potential of getting reassessed. How does that look in your estate planning process and assets being distributed? But that is the extent of it. Anything else when it comes to the tax strategy is something that you're going to need to work with your CPA or a tax strategist on. And then we can always make changes to the estate plan if they have specifics that they want us to from that tax strategy perspective. But a lot of times when it comes to this type of professional work, we work with professionals in different fields to come up with a comprehensive plan. The same thing with financial advisors, right? I work with financial advisors all of the time on what is that strategy going to look like for what those beneficiaries are, what assets they have, how are they going to be distributed, how are they going to have access to money. And it's the same thing goes with CPAs, right? Being able to work with them on what is that strategy going to look like. If somebody has passed, what does it look like from an accounting perspective to be able to get the estate tax returns done? Okay, good question. Okay, next question. When you're creating a trust for a married couple, do you create one or two trusts? Well, as any lawyer response, I will say it all depends. And what it depends on is it depends on what assets they have. And so let's say that the couple has one home and the home was purchased together. Like it was purchased jointly as community property, in which case, in that we would probably just do one trust, and it would be a joint trust that would be created because the assets are held jointly. Where we look at creating multiple trusts is maybe somebody inherited a separate property either during marriage, or maybe they had separate property that they had purchased or inherited prior to marriage. And in that case, we could create one joint trust for the married couple, so it holds their joint assets. And then we have a separate property trust just for those separate assets of the person who has that separate property. And what it does is it really makes it clear what assets are held in which trusts. And also the instructions of how the trusts are to be distributed might be different, right? I've seen some trusts where we have a joint trust that holds the community house, the primary residence where the couple lives. And then there's maybe a separate house that is going to be distributed to a child from a prior marriage, right? An adult child. And so that language in that trust would be specific to distribute that specific home. Okay. And in another case, there could be where you have one joint trust and then two separate trusts. Because in that case, maybe both of the married couples, both spouses have separate property that they want held in their own separate trust. And so they would each have their own separate trust, and we would have one joint trust for the community property assets. Okay. So getting to more questions. How can I change the guardian for my kids? I already created the documents. So depending on the documents that you created, they can either be updated or you just revoke and create new documents. But you're going to have to legally make those changes with how those documents are going to be done. I don't know what documents they are, if they're just guardian nomination documents, if it's a will. Either one, though, you can either revoke it or you can amend it. Okay. Oh, you're welcome. Thank you. Okay. And it looks like I have time for maybe one more question. Let's see here. So if I didn't get to your questions this week, I will do those first next week. Sorry, I'm just going through the questions here. Okay. When a trust is amended, do you have to fund the trust again? So when you have a trust, your trust is going to have a specific name. That name is what's being used to title all of the assets that you are funding into the name of your trust, like creating a grant deed for a house, transferring it into your property. If you have a checking account, having the trust name as the account holder of your checking account, and lots of other different assets. So when you amend the trust, you're not changing the trust name. So you don't need to refund your trust with a different trust name because it's staying the same. If anything, when you amend your trust, it's important to just make sure all of the assets that you have are correctly named in the name of your trust. Even when we restate a trust, right? So it's not amending, because amending is where you change a specific part of the trust. Restating is where you just create basically a whole new trust, but you are restating it so you keep the same name. Oftentimes, we will recommend to people if they come to us and they already had an estate plan that was created years ago and they now want to work with us, we will generally recommend to restate the trust. It generally will be less expensive than having to go through and amend. But we'll keep the same name so that you don't have to go through and refund everything else. I have seen though, and especially like in divorce, where they had a trust that was created and it was a joint trust. Well, now we are revoking that trust. So that trust will no longer exist, and you are creating a new trust, which will have a new name, and your assets will then be in that new name. Okay, perfect. Okay, thank you so much for joining me today. I hope that this questions and answers was helpful to you. And again, if you are looking at putting an estate plan in place, please make sure to send us a message. You can write protect, and we will send you a link to get that free consultation for the estate plan set up. This is a phone consultation, and it gives you information about what estate planning is, why it's important, and what it costs. Okay, so please get that scheduled. And if I didn't get to your question this time, I will get to it next week when I go live. So thank you so much for joining me, and I look forward to seeing you next week.